Our distinguished guests, esteemed faculty members, participants, and students, good morning. We are honored to welcome you once again to the second day of International Conference on Legal Aspects of Migration Management. Today, we begin this morning with the session on EU migration law, which would be chaired by Professor Sanam Baykal from Toby University of Economics and Technology. I would like to invite our esteemed panelists as well. Associate Professor Sedat Sirmen from Eskişehir Osman Gazi University, Assistant Professor Naziye Dirikgil from Sakarya University, and Assistant Professor Ege Okakın Erbaş from Istanbul Gedik University.
Good morning to everyone. I will be chairing this interesting panel with some esteemed colleagues of mine whom I know quite well, most of them. And this is an honor for me. I am Professor Sanem Baykal, and I work on EU law, but not on migration, so I will try to keep up with the papers of the esteemed colleagues and try to direct the questions that the audience might have. And before we start our panel, I would like to thank Professor Gülün Bayraktaroğlu Özçelik for this great event. I was not able to be here yesterday, but I hear that it was a full house and everyone was so interested, and it was a very successful academic event. It is very nice to hear. Wish I could be here. I was abroad and I just arrived last night, but I would also like to commend my dear colleague, my dear friend, my former research assistant Gülün Bayraktaroğlu Özçelik for this excellent Jean Monnet chair endeavor. And in that sense, I'm hoping that this is just a, well, this is not even a start, this is just the middle, exactly, of her endeavors in this area of Jean Monnet scholarships, let's say. And in that sense, I would like to wish her good luck till the end. And I'm really glad that she keeps involving me in her events as well. So, I would like to start off in accordance with the order of speeches, but I will try to be as strict as possible. There are a few people that I am a little bit worried about keeping the time. I'm joking, but I will try to be as strict as possible, as I say. We will have like 20 minutes for each paper, and I will just warn my dear colleagues when they have only 5 minutes to wrap up. And in that sense, I would like to leave as much time as possible for the questions and comments of the esteemed audience. So, as they always say, without further ado, let's start off with Sedat Sirmen, whom I've known for like 30 years, something like that, since I was a small girl, little girl. And in that sense, Associate Professor Dr. Sedat Sirmen is now at Eskişehir Osman Gazi University. And, but of course, we know each other from Ankara University, and same kind of family, let's say. And in that sense, he will be talking about some high international courts judgments, decisions regarding the pushbacks in the progress of EU migration law, that is the European Court of Human Rights and the Court of Justice of the EU. So the floor is yours.
So, thank you very much. First of all, I would like to express my appreciation for being here in this wonderful symposium. To my very best friend, Ms. Gülüm Özçelik, and also my school friend, Dicle. And also, I'm so happy and honored to be one of the members of this chapter. And my moderator, Sanem Hoca, we say Sanem Hoca, Professor Baykal, is not only my professor, my teacher, my professor, and also my old, we say sister, maybe we could say it, elder sister in my life. So today, as I just would like to express these situations, I know that 50 minutes is 15 minutes. So I don't have any kind of... yes, I'm already, yes, I know it. So, today I would like to give the information about the European Court of Human Rights decision and the EU Court of Justice of the European Union decisions regarding to the pushbacks. So, what is pushback? Maybe I just would like to give some definition regarding to the pushback. The special rapporteur in the human rights is just make a questionnaire and just make a small definition regarding to the pushbacks. What is pushbacks? Pushback is just various measures taken by the states, so including the asylum seekers being forced back to the country from where they attempted to cross or have crossed an international border without access to international protection or asylum procedures, or denied any individual assessment on their protection needs, which may lead to a violation of the principle of non-refoulement. So in the pushback part, this is the important thing is, we have some concerns about the sovereignty of the states. So the states would like to utilize their sovereignty principle and would like to make a measure regarding to the mass influx of the irregular migrants to enter into their territories. And the second one is that these states, especially we are talking about the European countries, maybe the 27 one and also the 47 one. If the Court of Justice decision is mostly concerned with the 27 member states, but also we have Court of Human Rights decision that also concerned with the 47 states, or 48, or I don't know, not Russia and Belarus. So, due to the fact that this situation is concerning with the European countries have also some decisions or some institutions that these sovereignties is put into the pool, and these sovereignties is just left to the Brussels Commission or left to the European Court of Human Rights. So this is an important situation that these countries could not only say that we are the sovereign countries, so they should also obey the rules of international law, obey the rules of Court of Human Rights decision, obey the rules of EU law. So these situations mostly is a challenging situations for these countries, and the Court of Human Rights and the EU Court of Justice of the European Union has some interesting decisions regarding to these pushbacks, and now I'm going to give some bullet points regarding to these pushback decisions. So the First one, maybe it's better to make a distinction between the European Court of Human Rights decisions and the Court of Justice of European Union. The first one, I would like to focus on the European Court of Human Rights decisions. The European Court of Human Rights decisions, mostly we have, I think, 80, I know 80, maybe more, but I realized the 18 one regarding to the pushback decisions. Mostly focus on the Article 1 of the European Convention on Human Rights, which is concerning with the jurisdictional foundation situation. The other one is Article 3. The other one is also Article 13. And also we have the protocol, Protocol 4. Article 4 is also an important international source of the countries that should take into consideration. So, as a matter of fact, of course, in the UN Universal Declaration, the migration or the refugee status is kind of a human rights status that's not binded to the countries, but also is a kind of a rule that should be made by the countries. This is an important situation. And the other one is the European Court of Human Rights, especially European Convention on Human Rights, use these all positive international or positive convention articles regarding to these pushbacks. The first one is the establishing the jurisdictional foundation for the extraterritorial control. So we have plenty of cases. Mostly in these cases, the Hungary, Ukraine, or Italy, or Poland say, I'm sorry, but this is beyond our jurisdiction because of the fact that, first of all, we have to control the territories in order to be responsible for the infringing of the European Convention on Human Rights, but on the other hand, we don't even making this kind of infringement because this is not our sovereignty place. This is the border, this is the high seas. So in this part, the Court of Human Rights especially said that, I'm sorry, but these are very important. The vessel is also territorial. So the borders are territorial, or to transfer it to the third countries to create some transit zone is also is your jurisdiction. So the land checkpoint transit zone, the port states, or even the high seas that the convention, the flag law is going to apply. In these parts, the European Court of Human Rights said, you are responsible for these situations. The important thing is in the part that yesterday, Professor David, all professors concentrate on this situation is the non-refoulement. The non-refoulement article, the non-refoulement custom or the non-refoulement rule that is also prescribed in the positive international agreements is the main situation that the European Court of Human Rights is taken into consideration. So we have also Article 3, non-refoulement and mechanics of the indictment. In this part especially, the violations is going to be taken into consideration by taking into consideration the Article 3. In this part especially the UNHCR reports and also the reports regarding to the European Conventions, CPT, is also has influenced the rules, is influenced the court, especially they said that the violations should also be taken into consideration by taking into consideration the Article 3 because we have the process regarding to the expelling returnees could be under in a situation that is created as a security problem. So in this part, I would like to just take maybe regarding to the pushback situations. We have the especially in the Article 3, the A versus Pellant, the Syrian nationals who had received compensation from the Syrian army, they alleged that failing to comply with these orders put them at risk of 15 years imprisonment, torture, or death. And in this part, especially denial of access to Polish countries or through Belarus and Russia is kind of a pushback that is infringing the European Court of Human Rights decision. Also, we have in the other part we have the also Syrian national has a problematic situation, and in this part the court found that the Leros police station, which lacked outdoor space, natural light, and adequate hygiene, is violating the Article 3. Why? Because categorizing this detention as degrading treatment. So in these parts, especially, the Article 3 is the main concern regarding to these situations. Also, we have Article 4 of the Protocol number 3, especially in this mass influx situation. In these parts, the transit zones situation, the border crossings, especially the transit zones, these are the situation that the court said sometimes, especially in the Hungary and the Spain, in this part, they said these countries are also violated the Article 4 of the Protocol 4. So also we have the Article 5, especially the informal detention of the migrants prior to their removal. The Article 5, any deprivation of the liberty must be lawful and in accordance with the procedure prescribed by law. Also these parts, especially in this part, the very aggressive pushbacks regarding to the Greece border, especially in the boats, onto the boats, is also a very important infringement of the Article 5 of the European Convention on Human Rights. Maybe you can also remember these news from the media that the Greece aggressive pushback especially has so dramatic consequences to the situation. So this is the Article 5. This is also an important article. Also we have the Article 13. Why? Because refusal of the entry is part that according to this refusal you cannot make find an effective remedy in this situation. So these are very instant situations. The pushback is coming. There is a chaotic situation more, and then how these victims or in the vulnerable situation or the irregular immigrants could find an effective remedy in these situations. So this is also taken into consideration by the Court of Human Rights. So maybe we could also take into consideration, because I have only 5 minutes left. In this part, we have also the Court of Justice of the European Union. In the Court of Justice of the European Union, we have infringement decisions, preliminary, we say, court type of the European Court of Human Justice. In these parts also in the famous directive and is taken into consideration, especially in this part, especially which is against the Hungary, due to the fact that the Hungary is also the member of the EU, in these parts, the Hungary is not only liable for infringing the European Convention on Human Rights, but also due to the fact that the Hungary is the member of the European Union, the Hungary is mostly submitting the sovereignty situations into the conflict, and they said this is a very national security situation that I should make these pushbacks. On the other hand, Hungary is the member of the European Union, so Hungary should also take into consideration the positive sources of the EU regarding to the migration law. And yes, in this part especially, the European Convention is very important. That is submit a fine to Hungary regarding the costs, and the court's order is a very prominent order regarding to this EU law. And also in this part we have also the Court of Justice of decision also regarding to the to realize an effective right to asylum or the fundamental human rights situation. This is also an important court decision in the EU, and also especially the Court of Justice, especially the Lithuanian decision in the case, also take into consideration the domestic legislations preventing irregular migrants from applying for asylum during periods of mass influx violated the EU law. Well, as a conclusion, I could say that sovereignty versus the principles of law, the rules, is a very problematic situation and very controversial. On the other hand, today still the states would like to find some, let's say, lacunas regarding to these situations, especially some measures of Poland, some measures of Belarus, not EU, but still not EC, okay, but a European country, and also Hungary. These are all the countries still has war with the migration, irregular migration, and they do not want any kind of objection regarding to their national policies. But on the other hand, the EU and the European Court of, the Court of Justice and the European Court of Human Rights is trying to at least point the situations that is infringing the all maybe the 70 years assets of the migration law. Thank you very much again. Thank you very much.
Thank you, Professor Sirman. Of course, we will have a debate on all the presentations with the participation of the audience at the end, but I just wanted to say that it made me think about what's going on in general, not only in Europe, but in the world right now. It's this clash between the realist take of the world, the politics, and versus the principled, value-based, rule-based take on the view. So apparently there is this clash in Europe about the migration rules and their application in that sense, as far as you're concerned. So that made me think, so we can just maybe discuss some issues about this too, this idea of sovereignty being just high on the agenda of Europe as well. So, now we will move on to Assistant Professor Dr. Naziye Dirikgil, coming from Sakarya University, a dear colleague, and she will be giving a paper on new rules for managing migration, legal perspectives on return hubs, and EU migration policy. So from pushbacks, we are going to the return hubs, which is another current hot issue when it comes to EU's way of, or trying to find a way of dealing with managing migration. So, please.
Thank you, Jo. Thank you, dear Professor. I would like to present my paper here while I'm speaking. Let me try. It's not working. No, you have to push this. Which one? This. Okay. Yep, it's working. I'm starting. Hello, everyone. It has been a great pleasure to present my paper here in this atmosphere, and I'm quite thankful to the organizing committee, to all of those who have contributed to make this happen. Today I'm going to talk about return hubs. The term itself looks something quite innovative, as they say in the proposal. However, maybe the application itself might seem too familiar to all of us. So first of all, I would like to start with a little historical background of the EU migration policy. But when I was thinking this morning, when the first time I witnessed with the migration policies of EU. Maybe I'm mistaken, but it made me think about the Maastricht Treaty when it established the three pillars, and the third pillar, one of the headlines of the third pillar was about migration. And it was about the migration of third country nationals, but it was not about the externalization of migration policies at that time. It was about the migration management. However, over the years, with the waves of migration, the EU policy, with the pressure of the governments and the public, and the EU institutions also felt the pressure to change some sort of migration management strategies to become something like externalization of migration policies in recent years, especially. So, some of the recent developments about the EU migration law is the adoption of EU Pact on Migration and Asylum. This has become operational in 2024, but some parts haven't been operationalized yet. Some parts, I think, are going to be operationalized in 2 years of time. So this is one of the innovative ones. Before I was going to the proposal of return hubs, I wanted to emphasize this one because they're closer, they have closely linked to each other. So these EU Pact on Migration and Asylum actually creates a common and integrated system for asylum. And it also introduces some sort of approaches, the screening procedures at external borders. So it requires some pre-entry screening at external borders. And it also expanded the use of Eurodac, which is like some sort of fingerprint system that collects and compares fingerprints all over the Europe. So it doesn't need to be, actually the main idea of this to prevent multiple applications or from any other EU countries. So, and another key aspect of this EU Pact is asylum decision making, making asylum decision process quite faster. And they also emphasize in the Pact the solidarity and responsibility sharing mechanisms, because some of the countries who are closer to the transit countries take the most of the burden, and then they should emphasize the responsibility sharing mechanisms compared with the necessity of the situation. And at the same time, it also includes some sort of externalization strategies, which then also end up with the return hubs proposal. So in 2025, 17 countries submitted a proposal and asks for a more effective return and highlights the needs for a legislative reform on that purpose. EU Commission took this initiative and also proposed a return hub proposal. The full name is not a return hub proposal, but it is quite practical to address it as return hub proposal. The full name is quite a long one, but establishing a common system for the return of third country nationals staying illegal in the Union. So as we see, the proposal has been done, and it also includes something quite interesting. Because it includes a new term inside of it, which is so-called return hubs, and it also the Commission itself also opted to propose a proposal rather than a directive, and this regulation actually is the regulation that also replaced the 2008 directive. So it looks like opting for a regulation rather than a directive. This time the EU Commission shows a stronger eager to provide more concrete terms. This is how I read it. So the return system based on these pacts is expected to become operational. Operational by 2026 with this one as well. So what is the context in this return hubs? In these return hubs, there is a long definition in one of the paragraphs of it. However, the main aspect of it highlights the three main things. The first one is this can be an agreement or an arrangement that can be done by EU member states and third country nationals. The second one is that parties of the agreement or arrangement should ensure the respect of the fundamental rights of the people concerned, especially the principle of non-refoulement. And the other one is these hubs would obviously temporarily hold people who have received a final return decisions. So in that case, those people who are within the EU territory, and these are the ones who received a return decision, and they are not allowed to stay in the EU territory anymore. So from this reading, they don't have they are not in the category of asylum seeker anymore. So this is maybe something that can be read something new, other than the bilateral agreements that has been done between UK and Rwanda and Italy and Albania. Because in those bilateral agreements, they were also trying to create some sort of return hubs, but it was within the context of asylum seekers. So maybe this is the part why the European Commission addressed it as an innovative way of addressing migration waves or flows. The proposal now has been actually addressed by the Council, and the Council itself also put their position, and they also supported the idea of strengthening the return policies, and now it is in the process of it is in the European Parliament, actually. So looks like it is going to be operational 2026, but let's see how it's going to end up. So the stronger return procedures, establishment of return hubs, and mutual recognition of return decisions across EU states are the main objectives of the titles that can be seen in these return hubs. So the main aim to address all the issues of EU migration policies in these return hubs is to increase the rate of irregular migrant returns, because as they also include inside of the proposal, only the 20% of people who received the return decision actually left the EU territory. So the 80% is somewhere within the EU territory. So they are concerned about the high level of people that already stayed in the country. So with these return hubs, they were thinking to convince people when they were sent or returned to the return hubs, they might feel like they would be, it is time for them to go back to their country of origin or somewhere else. So this is the first assumption that actually EU expecting. So another aim of this return hubs is to strengthen cooperation with third countries. The strengthened cooperation with third countries looks like something quite good. However, it is one of the part of EU's externalization policies, because in order to strengthen cooperation with third countries, it requires to make bilateral agreements or arrangements as it has been defined in the return hub decision. So, however, the return regulation also aims to reduce the pressure on EU asylum system. EU institutions and EU governments feel the pressure of the asylum system, and they were thinking like by relocating irregular migrants who have exhausted their asylum claims to facilities outside the EU, member states hoping to reduce their administrative and logistical burdens within their own territories. However, this burden this time is going to go to the other side, which are called as third countries. So another aim is to create a more structured and harmonized approach. So they include a European return order. So with this mutual recognition, if one country, EU member country, made a decision of return, the other EU countries would automatically apply this decision. So this would help them to multiple applications of prevent the multiple applications of EU decisions, and it will harmonize the decisions within the countries itself. So the return hub proposal, if the parties want to complete some sort of bilateral agreement or arrangement, it requires parties to include some of the elements in it. We can also call them as some sort of safeguards. So those safeguards are the following: the procedure for the transfer, the conditions of stay in the third state. So in these conditions of the third state, both parties, the EU member state and the third country party member state, should be responsible in that aspect. And they also need to include some sort of elements about the procedures of onward return. If the person cannot return back to the EU member state, what is going to happen in the next steps of those peoples? If the consequences of onward return would not be possible, then what are the next steps for those people? And also, the return hub proposal also wants those bilateral arrangements or agreements to include respect for human rights, especially the principle of non-refoulement. I keep mentioning the principle of non-refoulement because once we talk about externalization of migration policies, the principle of non-refoulement is one of the main principles that has been violated repeatedly. So I think they were trying to show some sort of sensitivity in that aspect. And another aspect or element that needs to be included in these agreements is independent monitoring mechanism to verify the effective application of the agreement. So among all those people, two groups are exempt from receiving return decisions. One is unaccompanied minors, the other one's families with minors. So those are not receiving return decisions or asking to leave EU territory. So the Commission here enters into the scene because as far as I see, I couldn't see the EU institutions along with those return hubs. If prior to completing some sort of bilateral agreement or arrangement the parties needs to inform the Commission and other member states. However, still, I'm not quite clear about the EU institutions' role here. It seems like, or maybe that was the main aim, the legal basis was provided by the EU Commission or EU institutions. However, the main role here about the return hubs based on the national application of the station. So, when we look at some of the legal challenges of these return hubs, it gives some sort of two options to the countries, arrangement and agreement. As far as I understand, an arrangement might have a weaker normative effect on the respect of safeguards of irregular migrant protection, and this might end up a violation of some fundamental human rights, either in the third country state or even maybe in the member states which are not taking into account for the main principle of non-refoulement. The other one is the role of EU institutions are not quite clear here, but I think it was maybe intentionally done because the main role was aimed to give the national EU member states and maybe give the burden on them, because if the main fundamental human rights violations has happened, the accountability would rely on the national authorities or the third country. Obviously, externalization of migration control is quite obvious here because when they refer to a third country in the Article 4 of this return regulation, a third country can be any third country that are acting incompatible with international law and respect for human rights. However, there is no limitation or geographical limitation, or there is no or understanding or criteria to decide where to return those people. Because of there is no geographical limitation, does that mean that EU member state can make a bilateral agreement with any country in any continent and send the people to those countries, and maybe if there's no, and to those countries, and those people maybe have never been in those countries and have never been any personal connection. So it is a quite broad explanation about the third country and bilateral agreement. Another aspect of this, or another challenge of this return regulation is the term return, because they also mention in the paragraphs saying that people who are received return decision and who are not allowed to stay in EU territory anymore are illegal stay, are making like some sort of illegal stay, and they are posing a security risk. And once they pose a security risk, so once they fall in that category, EU has a right to send them or return them to the third country national. So it looks like the voluntary nature of the decision has been gone, and the people were forcibly returned to their country of origin or the third country nationals, even if on the paper it looks like a voluntary return. So these are the parts that I find a little bit like problematic, or maybe I'm quite critical on that aspect. And for the final points, the principle of non-refoulement is the main thing that needs to be respected in that aspect. When those people return to the third country nationals, it should be evaluated if they are facing some sort of persecution that has been defined under EU, under 1951 Geneva Convention, and if they are facing some sort of ill treatment in those countries or in their country of origins if they are sent back to there, and if they had to make seemingly voluntary decisions to return there. And if they are not voluntary return to those countries, actually the term return is not quite explaining the real meaning of their movement. It looks like it's going to be like expelled. They are being expelled to those countries. So what I think that obviously the recommendations we have been seeing in many EU documents many times, I wouldn't say something any different than those documents, because respect for human rights, safeguarding of principle of non-refoulement, more burden sharing, more responsibility sharing, more maybe social inclusion of people who have felt to leave their countries and reach their territories. And maybe clarify the state responsibilities between the third country national and EU member states, because looks like the more burden is on the third country national in those bilateral agreements. And obviously the people who needs to leave the country needs some sort of legal assistance, and maybe judicial review should be included in that aspect. And the monitoring mechanism should be at the EU level. Thanks for listening.
Thank you very much, Naziye Hocam. Very, very good and clear presentation, and a critical take on the new return regulation, or the preparations of it, and how the EU is trying to control returns from a new perspective, and how this becomes quite a strong element of externalization of migration, with return hubs especially. So in that regard, it was a very clear and precise presentation, giving some strengths and the many pitfalls of the upcoming legal framework. Okay, thanks a lot. So now, again, an old friend, we were reminiscing about, what was it, 6 years ago, around this time, in Marmara University in Istanbul. We were in a panel together with Professor Ege Okakın Erbaş, and we both caught our first COVID there. It was like, the February of 2020. I did not catch it again, and it wasn't that bad for me, but still, most probably that was a very memorable occasion for us, but also we have met in other academic occasions too, apart from that COVID issue. So we are going to be listening to Ege Okakın Erbaş from Istanbul Gedik University on Frontex and the extraterritorial exercise of EU's administrative power. Please, the floor is yours.
Yes. Good morning, everyone. Thank you, Professor Baykal, for your kind words. I feel like we share a bound by destiny. It was our very first introduction to each other, and I was a PhD student back then, and I was an assistant professor. But thanks to her, she has a big role in my career, in my earning my PhD. So I'm very, very honored to be here with her. And of course, I would like to extend my sincere gratitude to the organizers for this incredibly timely event. It has been a privilege to witness all the contributions so far, such a rich exchange of ideas. Now, as the final speaker of this session, on a Saturday morning, I'm actually aware of my position, and I know that I am the only person standing between you and a coffee break. So I will try to be focused and inspired by the stimulating conversation so far. I promise to keep my momentum high, and as we dive into one of the most debated actors in EU overall in border management, Frontex. My presentation focuses on a specific dimension of not only EU migration law, but also law of EU agencies and EU administrative law more broadly, the extraterritorial exercise of EU administrative power, with a specific focus on Frontex operations in the Western Balkans under status agreements. Migration law is often discussed through the lens of human rights and international law, as we've seen so far here on this conference as well. But it is fundamentally an exercise of administrative power. So in this context, by looking at status agreements, we will deconstruct the legal architecture that enables the extraterritorial exercise of power and explore why traditional accountability mechanisms often fall short. To this end, I will start by defining status agreements and moving through the extraterritorial exercise of power and conclude with the accountability conundrum. First, let's establish that we are witnessing a shift from traditional diplomacy toward operational extraterritoriality, and Frontex, the European Border and Coast Guard Agency, indeed has moved from merely a coordinating role to conducting direct joint operations on non-EU territory. So under the previous regulation of, under the previous regulation of 2016 regulation, Frontex operations were limited mainly to neighboring countries, neighboring non-EU countries, of course. But the 2019 regulation marked a very important shift in this regard, and it expanded Frontex's reach globally, allowing deployments to any third country and authorizing its staff to direct executive powers on the ground. For example, Frontex is now active not only, let's say, Serbia's border with EU countries like Hungary, but also with non-EU neighbors such as North Macedonia and Bosnia. This expansion, both in territorial and operational way, is one of the most striking developments in Frontex evolution. So the legal basis is the status agreements between the EU and the third country, concluded as an international treaty under Article 218 of the TFEU. So far, there are 6 agreements in the region with Albania, Bosnia, Moldova, Montenegro, North Macedonia, and Serbia, allowing all joint operations on their territories. Once deployed, how do these teams operate? Formally, the host state, the third country, remains in charge. Command and control stay with local authorities, and Frontex teams must follow the host country's laws. Yet, despite this formal subordination, the actual scope of the status agreements is quite unprecedented. At first, they grant executive powers, as we said, including the use of force to EU team members, tasks like patrolling, document checks, gathering intelligence. For example, in Moldova, standing corps of Frontex were given access to national databases and carried out first-line checks at Chisinau airport, something never done before by EU personnel in a third country. You see a very small image of it. Yet this is not merely a matter of physical deployment. Oops, I did it again. These status agreements impact the host legal systems in three distinct dimensions. First one is the operational transformation, which we just discussed, granting direct executive powers to EU personnel. This is what happens on the ground. Second, legislative transformation, of course. This is the legal shield. It might look like alignment to the EU acquis, because these are all candidate countries, after all. To host Frontex, the state must align its laws with the EU acquis and incorporate the status agreements into their domestic law. Most critically, for accountability, this means privileges and immunities to Frontex staff. And third, fundamental rights transformation. States are required to redesign their domestic fundamental rights safeguards and create a complaints mechanism to align with EU standards as well. Let's look at the immunities first. Frontex staff, Frontex Standing Corps participating in the operations are granted immunity from local jurisdiction. Albania, for example, passed a specific national law that grants full criminal immunity to EU personnel. To understand the real implications of these powers, let's look at this immunity liability nexus. Well, in operations conducted within the EU, internal operations, the logic is straightforward. Article 85 of Frontex regulation, according to the Article 85, team members are treated as national officers regarding criminal offenses, meaning they don't have any immunity. As far as civil matters, the situation is governed by the Article 84, which establishes a clear liability regime where the host member state is responsible for damages. But what happens outside the EU is quite strikingly different. Team members are granted local total jurisdictional immunity, covering criminal, civil, administrative proceedings in the host state. So as a direct consequence of this legal shield, the non-contractual liability for damages is shifted to the third country, meaning, let's say, Albania or Montenegro pays for the damages. While a compensation mechanism is also existing, it is conditional and maybe practically inaccessible for a third country. However, the real risk, the real impunity gap lies in the criminal liability. The third country is legally blocked from prosecuting Frontex staff, but for seconded officers, seconded national officers, which like officers deployed by any member states, even they are immune in the third country, their home member state retains jurisdiction. Yes, in practice, this might be difficult. This jurisdiction may face some difficulties, but legally it's available, it's there. So if they cannot be tried in the third country, they can face court back in Berlin or Paris. But for statutory staff, this fallback disappears. Since they are employed directly by the agency, they have no sending state to recall and prosecute them, while, of course, they have a nationality, they retain their nationality, but the operational link to a national justice system is severed. They are, in principle, immune in the third country. Therefore, unless the Frontex executive director clears the way for local prosecution, either by waiving the immunity or by confirming that the act was not official. And because there is no EU criminal court or code, EU criminal code, to step in, risk of impunity appears. So this brings us to the third and final demand placed on host countries, ensuring mechanisms for fundamental rights protection. To balance these powers and immunities, the 2019 regulation introduced new internal structures before negotiations began to conclude a status agreement with the third country. A fundamental rights impact assessment to evaluate the human rights record of the host country is now required. All status agreements must include practical safeguards, such as mandatory complaints mechanism for victims, and oversight by the fundamental rights officer within the Frontex, and the deployment of fundamental rights monitors on the ground. But how effective are these accountability structure in reality? First, these, of course, are all administrative remedies. We see a variety of administrative tools like monitors, reports, the complaints mechanism. Sure, they are important, but are they enough? These bodies and mechanisms, yes, they have some authority to investigate and report, but they lack executive sanctioning power. They function only as advisory triggers, as the final decision to act on their findings remains at the stake of the discretion of the executive director or the home member state, depending on the status of the staff, either they are seconded or statutory. So this, of course, forces us to look toward a different legal frontier, the EU's own judicial remedies. What legal recourses in general do third country nationals actually have if they are harmed by Frontex operations? As mentioned before, Frontex operates under the host country's command, and status agreements explicitly shift the liability for damages to the host state. The logic is if you're in charge, you're responsible, you pay for the damages. So locally, it seems like the victim can only sue, let's say, Montenegro, but not Frontex. But of course, third countries are not bound by EU law and or EU charter as well. So mixing legal systems in this regard can mean less protection for individuals or migrants. On the other hand, one might ask, does this arrangement let Frontex off the hook under EU or international law? Decisively no. Despite the host state command, the EU retains meaningful control. Meaningful control is actually an interesting word on this. They have operational plans. They have to prove, Frontex had to prove the operational plan, yes, with the third state in cooperation, but they also, Frontex, the executive director, has the right to suspend any mission which the third country don't have such an explicit competence on this. So crucially, as status agreements cannot override EU primary law, Frontex's conduct cannot be outsourced to third countries. In result, judicial remedies, whether actions for annulment or damages, remain essential constitutional safeguards, ensuring the agency stays fully accountable to EU courts, even on foreign soil, and especially for fundamental rights violations. Again, the question arises, how effective are these judicial routes in practice? Historically, they have been limited by stringent standing criteria and the difficulty of attributing misconduct directly to the agency. However, there is a very recent and promising shift. The Grand Chamber's decisions in Hamoudi versus Frontex and WS and others versus Frontex, delivered just last December, directly confront these limitations. Although these cases focus on violations at or near the EU's external borders rather than under status agreements, we don't have a case concerning the status agreements, actually. So But the other Court of Justice judgments, of course, their legal impact is broader in this regard. So they signal sort of that the agency can no longer can no longer hide behind the host state commands to evade its own obligations. So interesting to see this transformative jurisprudence in the Court of Justice. So, to conclude, if we strip away the legal jargon, the anatomy of this accountability gap is actually quite striking. First, the EU deploys personnel with weapons and direct executive powers onto foreign soil. This is the operational stand. Second, it wraps them in a legislative shield of absolute immunity. This is the legislative stand. And finally, it relies on ineffective administrative procedures, as European Ombudsman has also pointed out. And judicial remedies remain almost, we say now almost because in light of these new judgments, we used to say like not a practical possibility, but now we see some hope. But in general, judicial remedies can be said to remain almost a practical impossibility. So to conclude even more, the core issue is always simple as that: the power of the state without the guarantees of the law, of the rule of law and human rights, the protection of fundamental rights as usual. And if this model is to continue, there is a clear need for a reconceptualization of accountability in EU migration governance. Thank you very much for your attention. I think I stayed on my time.
Thanks a lot to Yehoja as well. A very good finish to this running theme of this trying to balance between the needs to manage migration and the need to also safeguard the fundamental human rights and rule of law. So in that context, of course, I know that she works on EU administrative law and agencies mainly. So Frontex is the agency in this area, and also not only because it is the agency, because of all the criticism directed towards its role in the externalization of migration, maybe, and also those alleged fundamental rights violations. So in that context, that was very good. And also when she pointed out to the recent judgments of the European Court of Justice and the take of the European Ombudsman towards Frontex, it really gives hope. So thanks a lot to all the panelists.